Hello all. Good morning, everybody. This is Raj. I'll be the host for today's session. And at Eeva Tech, we've launched this weekly webinar series where almost all the startups, not only the startups, but every entrepreneur or every business owner can secure their intellectual asset. In fact, we are the trusted partner in India, mainly in patent law, and we specialize in providing expert advice and services to various businesses, ensuring that there is a protection for their innovative ideas and intellectual property. So we help the complex world of patents, and we also safeguard your future for success. We have the senior most team in India, representing intellectual property rights and also mainly in the patent law. So it's been 13 years of committed work by Team Eeva. So we filed thousands of patent applications. Again, there are over 20,000 plus trademark matters handled since 2012 officially. Prior to this, our founder and chairman, Mr. Srinivas Madhipati, had also helped many startups and many individuals. So officially, there are like 6,000 plus patent searches conducted. And if you can hear me, just comment in the chat, or probably just drop in a yes. I didn't get a confirmation. If you can hear me and see me, just drop a yes. So for people who always wanted their patent illustrations job done, we've also helped many individuals. Okay, thank you, Shivagaru, Mamta. So you can also turn on your cameras because we would love to have you collaborate with us or be partnership. We are looking for many individual speakers. We've also supported thousands of individuals, inventors or startups and MSMEs. Thank you so much, Rajasilvan, Asir Garu, Sumaroshni, one of our guest speakers. Again, she's the main.
Thank you, sir.
Thank you. And feel free to unmute and ask in any questions if you have any doubt as we go through the session. So Eeva Tech or Eeva Patent Services, as a firm, we have helped IPFCs and EDCs, or the top institutions in India. We've enabled them identify and file IPs. So let me share my screen and quickly show you before we jump into the official session. So this will be a continuation to the previous week's webinar. And before we dive into the official presentation with Suma Roshni, because she's the trademark expert, again, as an individual, as a consultant, I've also trademarked my brand, or I've filed my application for trademark. So it's a commitment for the community which we are serving. So this is me. Again, the brand I represent would be Dampreneurs. But I had my own journey. It's a brand which is listed under Video Therapy Network, MSME. But coming back to, let me share. Okay, if everybody can see the LinkedIn page. So this is the official Eeva Patent Services. If you Google Eeva Patent Services, you'll find almost all our brand pages. So we've done consistently weekly webinars. So today's session is this. Most of them do not protect their brand. They just think that owning the brand, they have all the rights. But the true ownership of the brand, or whatever the logo which we have, comes only when it's registered. So this is one of the previous week's webinar where we spoke about how AI testing is revolutionizing the industry. Sri Venkat Sudhir Goligaru had delivered amazing. There is a replay of the same on our YouTube channel. So if you go to Eeva Patent Services YouTube channel, you should be able to see the replay. Again, we also offer the industry insights and the topmost news in the industry about how various startups are leveraging. And this is one of the live webinars. Normally, we do collaborate with other industry experts like NI, MSME. Normally, we do this yearly once, but we've decided, or we made a decision that it should be done like quarterly or monthly. So this is on IPR and commercialization. So many people, after getting the patent or no matter whatever the intellectual property right is, again, it needs to be monetized. There should be commercialization. Um, Everybody wants to make business, or everybody wants to generate revenue through business. Nobody does things just for the sake of charity. So we wanted you to get benefited by the weekly events which we are going to conduct. So again, every week, even next week, we will also come up with another interesting event. We are also available offline for almost all the events which happens in colleges or educational institutions. These are the pictures from National IP Yatra. Uh, Again, this is just to give you an outline or the gist of what's happening in the industry. So this is one of our expert. Again, he traveled all the way to tier 2 cities, helping farmers or other innovators from tier 2 and tier 3 cities. We have Sai Krishna there in the picture. So uh, stay tuned. In fact, we would love to see you as one of our active participants, not only in the online world, but in the offline world. So over to you, Suma. You will be able to share the screen. I've just enabled the access. And for participants, I guess if you are new in this webinar, in this weekly webinar, just type in FT first time. For the folks who know me, or for folks who's coming regularly, that's absolutely fine. We know you, most of you. Okay. Asir Rajaselvan, his first time. Any other first timers here? Just type in FT. Mamta Garu, okay. Mamta Rangaswamy, welcome. Yeah, Suma, over to you. Thank you so much. Well, we welcome all the first timers. Mainly the team Eeva, please welcome the first timers. Put it in the chat. Welcome them to the weekly webinar series. We would love to see you as our future speakers as well, with whatever the skill set which you have. Yeah, over to you, Suma. Thank you.
Yeah, thank you, sir, and thank you for your introduction about Eeva. Good morning, everyone. Welcome to our webinar on trademark application filing. I am Suma Roshni, working as a trademark associate, and I am going to be your speaker for today. Thank you for joining us. We will be exploring about precautions to be taken while filing a trademark application. If you have any questions during the session, please feel free to submit them in the chat box, as well as we will have a question and answer session at the end. Without any delay, I'll just go into the topic. This is the recap of last webinar. In the last session, we have covered about what is a trademark, identifying trademark classes, importance of performing a trademark search. I have showed you how to perform a trademark search, as well as what are the search engines used worldwide for performing a trademark search. In this session, I'm going to speak about trademark types and classes, jurisdictions and application types, and avoiding and some mistakes, and when to use TM or R with your mark. Here, this is the life cycle of the life cycle of trademark encompasses different stages. Starting with the search, the next step is to file an application. After filing an application, we receive an examination report from the registry. Once we receive the examination report, if the mark is either, we will get to know either our mark is accepted or we have any kind of objection. Once our mark is accepted, it is published in a journal. Once the mark is published in a journal, there is 4 months of waiting period. Anybody can oppose our mark if they think that our mark is similar to their mark. Once this opposition period is done, the next step is we get the registration. After our mark is registered, every 10 years, we need to renew our mark. So why is it important to file a trademark? Let us say trademark is nothing but an identity or a brand you are creating. Suppose if you are not filing a trademark, but you are using those products or a brand, and there may be some other person who has filed for this particular brand, and we are going to get some legal notice at some point of the at some duration of this business. So we always suggest the clients to register their brand if they are planning to use it. It's not only about ownership, it's all about registration. What is a trademark? A trademark can be any symbol, logo, or a distinctive design which is capable of differentiating your business product from the other businesses. Trademark includes sound, shape, or color. ICICI Bank jingles is an example of a sound mark. ICICI Bank was the first jingle was the sound mark was the first to be registered by an Indian entity, whereas Yahoo was the first sound mark to be given registration by India in the year 2008. These are the different types of trademarks. We have a word mark, device mark, shape mark, sound mark, color mark, three-dimensional mark. In India, we are able to file these six marks. LIC is an example of a word mark. It contains a word. Amazon, Flipkart are also an examples of word mark. When you are going to apply the logo comes under a device mark. This is a Starbucks logo, which is applied under a device mark. Torblano is a Switzerland famous chocolate, which has been applied for the shape. You can see the shape of this chocolate is triangular in nature, and for the shape of this chocolate, they have applied a shape mark. Sound. I am playing here. This is the Yahoo model which they have applied for a sound mark.
Uh, yeah, Suma, can you share the screen again with the sound? Did anybody hear the sound? Play it again. No, I can't hear it. Can anybody hear it? Yes or no in the chat? No. Probably, Suma, can you reshare the screen with the sound check option, like stop share? And
No, so
also,
this is the 100%. The sound itself is very less.
no. When you share the screen, the presentation, I mean, stop the shared presentation.
Yeah.
Again, when you share it, there's a small checkbox like Zoom allows the sound share. I'm also searching for the, if you check the small box with the sound share, then we will be able to hear it.
It's okay.
No, okay, that's fine. I'll see if I can play that from mine. But yeah, you can continue. I'll play the ICICI Bank jingle line. This sound is Yahoo Yodel or
Which has been trademarked in India. This is the first sound mark, not by an Indian entity, but this is the sound mark which has got registration in India first.
yeah.
Yahoo's. ICICI Bank was a sound mark by an Indian entity which got registration. Okay.
Okay, sure. Thank you, Bhagwati and Lokesh, for confirmation. Siraj also. I'll make sure I'll also share. You can continue. I'll share the sound in a while
Yeah,
once I
sure.
get it. In the meanwhile, you can continue. Yeah,
This
thank
is the Cadbury Dairy Milk chocolate, which you see. This is the packaging. This purple has been done as Cadbury purple for the color in a color trademark. The shape of this Coca-Cola bottle is done in a three-dimensional way. This Coca-Cola is an example of three-dimensional trademark. So what are the benefits of registering a trademark? You get exclusive usage rights. It gives the owner solo right It gives the owner solo right to use the trademark for specific goods or services for which it is registered. It gives you some legal protection. If there is any infringement, it allows the owner to take action against the use of the trademark. Somebody is already using our brand and they're providing them counterfeit products, then we can take action on them. That comes under trademark infringement. It by registering the trademark, it adds the value, it adds the brand value. uh, in market there are n number of phones available, so Apple, Samsung, Oppo, Redmi. So we are able to differentiate the phones with the brand they are associated with. So by registering we get a market differentiation of the brands. We can gain a consumer trust and loyalty. If you want to expand your business globally, we always suggest to register a mark in India first, and then you can expand it globally. This is a success story of Nirma. This is an Indian brand where they started selling detergents from home to home. They used to go to each home to sell their products. Nirma started as a low cost detergent alternative to the well established brands like Surf. By offering some affordability, quality, Nirma quickly became a household name. It has a very strong brand identity. During our childhood, we used to see ads in television where this catchy jingle is the washing powder Nirma along with a muscat, a girl trilling. So it has a strong identity with the consumers. What are the steps taken by this Nirma founder? Nirma founder has registered and protected their brand, and also he took a legal action to prevent imitations. The first trademark of Nirma is applied in the year 1975 in class 3 for the goods detergents. Whereas now, if you see the recent trademarks in the year 2024, we can observe that they have expanded their goods in class 3 to perfumes, some oils, cosmetics, dental products, and hair lotions. So currently, Nirma has applied for trademark in all the classes. So, as we all know, trademark comes to the total of 45 classes according to NICE classification. NICE classification is something which is used worldwide classification. And in NICE classification, 1 to 34 comes under the goods. Suppose if you are manufacturing something, if it is an end product, that comes as the goods. Whereas classes 35 to 45 comes under the services. Class 35 is for retail and wholesale businesses, whereas from 36 to 45 covers different services we are providing. Some of the examples of classes are class 5 is for pharma, class 35 is for business. Like from class 1 is for chemicals, class 2 is for paints, and there are n number of goods divided into each classes. So how we are doing a business to class mapping? Let me take you an example. I want to start a restaurant business which falls under class 43 for food services. So I'm going to apply my trademark in class 43, and because I'm doing a business, I'm going to apply it in class 35. After starting this restaurant business, I felt that I want to manufacture my own water bottles instead of buying some well-known brands like Inlay or Bisleri. So I'm going to use the same name for my same name as my hotel name for my water bottles. So water bottles falls under class 32. So I need to apply for water bottles as well. And after some point I thought of I'm going to sell some products like chips or cookies. Then again I need to apply in class 30. So based upon the service and goods which you are providing, we are going to decide on the classes. Okay, so first I'll explain about Zomato. The main function of Zomato is a food delivery platform, which because it is delivering food, it falls in class 43. Why he has registered in class 35 and 39? Class 35 because they are advertising and they're doing online advertisement. That is the reason they have registered in 35. And because they are the delivery partners, he has registered in 39. So each business there will be a multiple classes where they need to apply for. Depending upon the type of the business and the products they are selling, we are going to map to the classes. Next example is Oyo Rooms. This is a platform where we can book a hotel rooms. Even hotel services comes under class 43. So hotel, lodging, accommodation, and food all falls under class 43. So his primary registration has to be in 43 as well as 35 because he's doing some sort of business. Next example is Airtel. Airtel core service is telecommunication and broadcasting. So his core service is like it falls under class 38. Whereas he has filed in class 35 because he is having online retail stores, they're doing advertising and they're doing telemarketing. That is the reason he has to choose class 35. Why he has gone for class 39? Class 9 covers wide range of electronic devices and hardwares. For signaling, for telecommunication signaling, they are using lots of equipment. So that is the reason they have choose for class 39. Next example is, let us say a vendor is selling fresh and roasted peanuts. Because I started a brand, I am registering it in class 35. Fresh peanuts comes under agriculture products. When it's agriculture products, we need to register it in class 31. And roasted peanuts are nuts like almonds, dairy, falls under class 29. So, so for doing a business on fresh and roasted peanuts, he need to apply in these three classes, 31, 29, and 35. This is how we are going to do a business to class mapping. What happens if you file it in a wrong class? Suppose I am doing a business of clothing which falls under class 25, but by mistake I have applied it in class 3. In class 3, it is for cosmetics, detergents, hair oils, and some dental products. I am not going to get any protection because the products which I am manufacturing is clothes and which I have applied is of different category. So we cannot stop any counterfeit goods. So it is better always to double check the classes before applying. uh, where you are going to file your application. If you want to file an Indian application, we are going to file it nationally. Suppose you are expanding your business globally. There are two ways to file international application. One is file in an individual country where you want to expand. Other is like following the Madrid Protocol. Madrid Protocol is a treaty between few countries. At present, there are 131 countries. Qatar is the latest addition to this Madrid Protocol. So, if you want to apply in any of these 131 countries, originating office being in, we can file an application through Indian Trademark and Patent Office directly in any of these countries. And where you need to apply, wherever you're going to sell your products or wherever you're giving your services, it is always recommended to apply for trademark in those countries. What is a Madrid Protocol? Madrid Protocol is a treaty between these countries. Instead of applying for each individual country and waiting for their response, uh, uh, so this they have formed as a treaty like Madrid Protocol. In this, we can apply a single application in in all these 131 countries, where first we need to apply an Indian application. Once we finish applying for Indian application, we can select an Indian application originating from India. This means that if I am a citizen of India or if I am having a business in India, the first thing I have to do is I have to apply an Indian application. Based on this application and based on the reference of this Indian application, we are filing an application internationally. So we can select any number of countries in Madrid. So there is a single fee system. Madrid application take fee only in Swiss francs. To fill a Madrid application, we can either fill it in English or French or Spanish. So this is the easy way to expand your business globally. When we file a Madrid application, we need to get our examination report in the first 18 months. These are the rules set. This is the rule set by them. What are the Indian brands that are using this Madrid protocol? Infosys and Patanjali are the brands which are using Madrid protocol. So, what does claiming a priority mean? Suppose today is 4th June 2025. I have applied for an Indian application today. And after 3 or 4 months, I thought like I want to expand globally. If I apply my international application before 6 months, that is 6th November 2025, I can claim the priority date. Even on those countries, even though I have applied within first 6 months, I'm going to use the date today, like first 4th June 2024. So we are going to claim the priority, which is Indian application date. This will be very useful for global brands. Now coming back, what are the different types of applications while applying for a trademark? Any individual can apply for a trademark, or any startup or MSME or a company. If you are applying for it as an individual, you need some different set of documents. And if you are applying as a company, you need an incorporation document. And if you are applying as a startup, you are going to get fee concessions. Right now, SIP Startup India, if you have the Startup India till 31st March 2026, this scheme is available with government, and which lowers your fees for applying for a trademark in India. What are different types of applications? The first and the foremost is single class application, multi-class application, series mark, certification mark, and collective mark. Along with this, if you are from any other country and they are claiming a priority date, as I mentioned before, if you want to claim the date in India, you have single class convention application, multi-class convention application, series mark convention. So you have this along with for claiming priority, you have convention applications. See, suppose if you want to sell only one product, see, there are many companies like pharma companies, they sell pharma companies, they sell tablets and all. They want to apply it only in class 5 for the drug. So they, in that case, they are gonna apply it as a single class application. And if your goods and services falls into two different classes, then you need to go for multi-class application. McDonald's is using a series mark Mac. See, when you see the McDonald marks, it is like McChicken, McCafe, Chicken McNuggets. This Mac is a part of a series. So if you want to apply a series of products for your company, then you should choose series mark. Next, coming to what is a certification and collective mark. A collective mark is a type of trademark. It's used by members or an association of a group to distinguish the goods or services from those of non-members. If you see that for CA, there is a collective mark. They have formed as an association and they have applied for a trademark. That is called as a collective mark. What is a certification mark? Certification mark is something it assures consumer about certain characteristics, quality, or service, such as the materials used or something like that. It meets specific standards and it assures the consumer. Silk mark for saris. If there is a silk mark, they say that they are using the pure silk in the saris. And for gold jewelry, it is BIS hallmark. So based on this certifications like BIS or series, the customer feels that there is certain standards of quality going into the product. This all comes under a certification mark. But we never suggest a client to go with multi-class applications, because suppose if you are applying your trademark in 3 or 4 different classes, and if you get an objection, if you get an examination report saying that there is some objection in one particular class, we need to wait till this objection is cleared so that it gets to register in all classes at a time. Rather than that, if you are applying it individually in single class, if one class is pending, 3 classes will be registered. For this class, uh, you can file an examination report, and if there is a hearing, the advocate can attend the hearing and clear this objection. So because of one application, we are not gonna hold the all the entire application. So we are suggesting our clients to go with a single class applications. What are the requirements for filing an application? We need to know the name of the brand or the name of the product. Along with the name, are you going to do, is there, if there is any logo, then if there is a device mark, you need to provide us with the logo, the classes which you are interested for your goods or services, and we need an address proof, like a address proof, which we mainly ask for Aadhaar. So now you have decided to file an application. Along with these, there are 2 more documents which we require. One is the power of attorney. What a power of attorney is, you're giving permission for a trademark agent or an advocate to appear in front of trademark registry on your name. So it must be signed by both the parties, by the agent as well as the person who is authorizing us. So this is a legal standing which is essential while filing a trademark. While you're filing a trademark with an advocate, with a trademark agent, if you're filing it individually, there is no need of power of attorney. If you're filing with some advocate or attorney, you need to sign this and you need to provide this to the attorney. So while applying for a trademark, there are 2 ways where you're either we are applying it as proposed to be used or used since. Suppose you are new, you want to start business in next 2 or 3 months, then you are going to file your application as proposed to be used. Whereas if you have already been using the mark and now you got to know about trademarks, and now if you want to apply for a trademark, then we are going to say it is used since from which date, whichever date you provide us, that date we are going to use here. So if you are already using it, we need to submit an affidavit which acts as evidence. This affidavit contains information like when you have started the business and how you are using this mark, what is the turnover for each area, and this should be notarized by a lawyer. Like in India, uh, whoever applied for the mark will get the right, and whoever is using the mark, both the people have the equal importance for the registration. Suppose I have registered my mark first, but there is some other honest user which who is using the mark from past 5-10 years, and so even he gets his mark registered. See, when it is coming to schools, there will be a name like Nalanda, which is a common name. So now I thought I am going to name my school as Nalanda. So I'm applying for a trademark. I may get the registration because I am the first one to apply with this name. But somewhere in India, there is already a school which has been established from past 10 to 15 years, and they got to know about trademarks right now. And if they want to apply for a trademark, they are also given the right to use the trademark because of this section 12, they are a honest concrete users. This here I have quoted one example of such case, Priya Foods. Despite filing after a competitor, they have given the rights because Priya Foods is already in business from past few years. When you are claiming a user date, means when you have told in your application that you are using this mark from past few years, then you need to submit proofs. Along with affidavit, we need to submit some proofs that you are in business. Suppose if you are running a school, the fees which are paying by children can be used as a proof. Suppose if you are doing a restaurant business, invoices, shop images, if you get any awards, those can be used as a proof. It is always advisable to get more proofs, because it shows that strongly you are using this current brand. Suppose there's a Reliance company. Reliance is the group which has n number of companies in its group. If your business is if your business is related to group business, then we always suggest you to take NOC from the group, because uh, I came with an X company and I am authorizing Y company to use my company's name. So in that case, I need to give NOC from my side, which has to be notarized. What are the common mistakes we are doing while filing a trademark? While filing it in a wrong class. If we are filing it in a wrong class, it is not going to be protected. Descriptive names. Descriptive names, those are the suggestive names which describes the business. If we are using user claim date and we are not submitting any affidavit, any proofs, any invoices and all, then in the examination report, we are going to get objections. It's if it is a group company and we are not providing any NOC. NOC must be signed by the board members of those company. If we are not submitting these proofs while filing an application, the next step is we are going to get examine it in an examination report. What is a descriptive versus what is a coin mark? See, fast pain relief. Pain relief medicines come in class 5 for pharma products. If you are using for some ointment fast pain relief, it is very descriptive and it is likely to be refused. So it is always better to coin the word, use a unique one for your brand name. Zerodha is a brokerage company that offers low cost or zero brokerage in trading and investment business. So the names like this for their business is highly protected. These are the some more examples of trademarks with different. Flip cart. Cart is the normal word. Cart is the thing when we go to a supermarket, we use a cart to purchase all the things. With cart, they have combined flip and they have coined a word flip cart. Zomato for food business is an invented word. The next is an example of Nika. Nika is derived from a Sanskrit word Nayaka, which means actress or one in the spotlight. So Nayaka, Nika, they have derived it from Sanskrit word and they are using for the cosmetic business in class 3. So you need to coin it and make sure your brand is unique to yourself. Once we file the trademark applications, we are going to get an application number which is used throughout the life of the trademark. Once we get this acknowledgement from the trademark registry, we can start using TM symbol on our brand. What does this TM symbol says? It says that we are in a process of registering our trademark. We have applied for it and we are in a process of getting the registration done. This TM can be used only when the registration is pending. When can you use the symbol R for your trademark? R can be used only after the grant of the trademark. Like you cannot use it before the grant. Like if it is still in the stage of application, you can use only TM. If not, you are using art during that stage, it is a punishable offense. There will be a fine of from 50,000 to 2 lakhs and imprisonment of up till 3 years. So it is always recommended to use R only after you finish the registration for your brand. Before that, it is always advisable to use TM. Is there any questions?
Okay, for all the participants, if you have any questions, please drop it in the chat. And let me just play the sound, the trademark of the songs, which are already published on our social media handles. So let me share the screen from my end. Okay, everybody can see the screen, right? So on World Intellectual Property Day, we published signature sound. Okay, let me share it again. Yeah, the sound share is enabled. I'll play it multiple. Drop in a chat saying if you can hear the. Okay. This is Netflix. Almost all of us knows the Netflix. So let. So those are the three sounds which were given there, and let me play the other sounds from the screen here. If you can, too low, but I'm sure you heard the Yahoo. It's the ICICI Bank one. So we have a question there. Sumaitis, Abhilash asks, can you please share the complete time duration of trademark filing stage by stage? Suma will walk you through that. Yeah. Before you share the screen, Suma, just give me like a couple of seconds more.
Yeah, I'll just answer it verbally, so no need to share the screen.
Okay.
Right now, the time taking, once we file an application, immediately within a day or two, we will get an acknowledgement. Before it used to be like within 4 or 5 months, we used to get examination report. This yesterday, now we are receiving last year's June's examination report. Once we receive examination report, we get to know whether our mark is accepted or if there is any objection. If there is an objection, we will end that we have received an objection. Sometimes we may ask for more proofs. Depending upon the objection, we will be asking for the proofs. Once the client is okay and client is providing all the proofs, we will be uploading our reply, objection reply. And right now it is taking more time. Even after uploading the objection reply, it is taking 1.5 years to get a hearing. On the day of hearing, the registry will decide whether mark is accepted or refused. If the mark is accepted, then it is published in the journal. As I told you, after the mark is published, we have 4 months of waiting period. Anybody can file for opposition in these 4 months. After these 4 months only, it is registered. If there is no oppositions during this period, then this mark will be registered. So right now, because of the delays from trademark registry side, it is taking a long time. See, in this current scenario, if there is no objection also, it may take 1.5 years to register the mark. If there is some objection and hearing it may take the long, like 2.5 years right now, because it is not because of any individual company, it is because of the trademark registry. And there is one more option, like if you want to know, there is one more option, like if we pay like 20K to the trademark registry, they will process this application faster. See, we say like Tatkal, they process it faster. So if anybody is hurry in getting the registration, they can use this.
Okay, so we can expedite the process.
Yes, we can. That too, within maximum of 2 to 3 months, you will get the result.
So the application filing,
No, first we will do a search, sir. Once a client comes to us, the first step is identifying in which class his business falls and doing a search. After doing a search, then we are going for application. Then we will apply. If within a day or a two, we will get an acknowledgement for this application.
oh,
From application to examination, right now it is taking 12 to 14 months.
okay.
This month we are receiving objections for last June's application. It may change, it may take longer time or it may take shorter time, depends upon a trademark registry.
Okay.
Mm.
But obviously the expedition is possible by paying the extra amount, like 20 additional.
Yes, yes. We can fast forward our application by paying the 20K to the trademark registry.
But normally we get the TM, I mean, the registered certificate within a year, right? In case if it goes through the regular process.
That's what I'm saying. Right now, to receive an examination report itself, it is taking 1 year, 2 months that time.
Yeah.
So, in the present scenario, which is happening now, if there is no objection, it will take 1.5 years easily to
Okay.
get the mark registered. If there is no objection, if there is an objection, it will go to 2.5 years.
Yeah, it'll be delayed further.
Yeah, because once we file an objection reply, in some cases we get a hearing. So based on all this, it is taking time.
And also, Abhilash, we have the replay of the same on our YouTube channel. We'll drop in that link. And for the participants, Lokesh is asking, what's the difference between the sound mark and the copyrights included in the music? So difference between the sound mark and the copyrights with respect to music. It's in the chat, Suma. I mean,
Yeah, I'm saying like Spandana can explain about copyright, sir.
Okay. Yes, Spandana, can you unmute and
Is
basically
Spandana available?
the copyrights is a different team, but again, trademark. So Vijay says he's transcribing this call, which is absolutely fine. Tactic A extension. Okay, great.
In copyright we can include lyrics also, like text, anything we can include, we can file copyrights.
Okay.
For trademark we can include only music related, that minimum bit only.
Okay.
Copyright we can upload total file including music, lyrics, like that.
Trademark is basically for about only 30 seconds, sir.
Okay.
Whereas like complete songs and all, they are doing the copyright.
Yeah, Lokesh, we hope we answered your question. So copyrights involves probably the sound, the music composition and all that. Probably jingles or anything less than a minute. Even the ICICI Bank jingles, which we not only the jingle, they had different versions.
Whatever it is, we can upload only till 30 seconds, sir.
Okay, that's
That
the
I am sure. There is one more question, sir. Let me answer that.
There is also Airtel sound marks which had been registered. So another question, duration is less for trademark. Okay, yes.
Is there any option to oppose any registered application and time limit that makes opposition application? See, there are two ways to oppose an application. One is one period is like before registration and after registration as well. If we feel uh, it is similar to our mark, we can oppose in the first 4 months after publishing it in journal, or post as well. We can oppose anytime throughout the time period.
Okay, and we have another question from Asir Rajaselvan. Like, what's the cost of registering the trademark and copyright? Is it the same or is it different for trading? The cost of trademark application and registration? Suma or Satish, if he's there, or anybody.
Again,
as I know, probably the government fee will cost around 4 to
Both
5,000.
different, sir.
Sorry?
Both charges are different, sir. For trademark, government fee will be 4,500.
Okay.
Again, if it is a word mark, it is 4,500, sir. Again, it is a device mark, the price is varying. If it is depends upon which marks we are
Also,
selecting.
sir.
Yeah, so Asiraj Selvan sir, mostly at Eeva, again, we make sure that only the government fees, the
No,
profession.
for individual it is 4,500, for corporate it is 9,000 for trademarks.
Yes, sir.
Whether the same for copyright or different is matters.
Copyright based on work, government fee will be changes, sir. For a single or entity, both are same, sir.
What is the minimum?
Government fee will be for literature work 500, sir. For audio or sound recording, artistic work 2,000, sir. For video or cinematographic film 5,000, sir.
That is cheaper.
Yes, sir.
Okay.
It's, I mean, initial filing and all the steps, production is little cheaper. So they say prevention is better than cure, right? Normally, if somebody uses it or monetizes it, or again, as per copyright law, everything is protected. But if it's not protected, the losses will be more, which you know. If somebody uses it for commercial purposes, then you get to see the loss. So, Gajanan, more. Is there any option to oppose any registered application and time limit that making opposition application?
That's what I told, no, sir, already. We can even if the mark is registered, we can oppose it, but we need a solid proofs.
Okay.
There is no time limit to oppose a registered mark. At any point of time, we can oppose a registered mark, but we need to prove that we need to have certain proofs.
Okay.
Mm.
Probably it could be the invoice or something online which shows that it's been published in the
If
past.
the name is similar or phonetically similar, those cases, and if we are already started our business with our mark, if they are copying, we can go for post-registration opposition as well.
Yeah.
They
Again,
call it as a rectification. This is the opposition. The 4 months period after publishing his journal is called as opposition, and after post registration we call it as a rectification.
yeah. And I remember a couple of examples again, be it in the Bawarchi, under food businesses, there are lots of oppositions.
Yes.
There are various examples. Even with great brands under Badam Milk, probably there are brands who also had I mean, they fought their legal battles with Amul brand. There's so many news about the trademark battles. If you just Google the trademark oppositions, you'll get lots of other examples. Again, in sound space, there are very low number of players. So, okay, there you probably let me share the screen again.
Wait, let me share the PPTs.
Yeah. So, and there are a few participants like Abhilash and a couple of other participants. If you have registered on the link, on the registration link at bit.ly Eeva Tech, you'll also have a copy of this PDF for the presentation, and you can catch the replay through our official YouTube handle. So, with respect to for the participants who are active mainly, we request you to just search for Eeva Patent Services. You should be able to find our Google Maps link, Google review link. Let me drop that in the chat as well. And anybody else, any other questions? Is wordmark very important, especially when your logo is not finalized? Yeah, definitely. In fact, the first application will be through wordmark, Vijay Kumar Gupta. So initially in the trademark filing, for instance, when I had been through, like, for instance, in fact, my own personal experience when I went with Team Eeva, when I applied for like entrepreneur, bookpreneur, authorpreneur, when I applied for the word dampreneurs, like damn sure, damn good, and damn right. Let me just bring that. So that's what I realized. So the word mark is what the initial application which will go through. So I didn't finalize the logo for the word dampreneurs, like damn good, damn sure, damn right, and all that. So we initially filed the application for the word dampreneurs. The logo had not been finalized. There could be an additional application with the logo once the design is finalized. And the filing fee again will be 4,500 or below 5,000 as the government fee. The professional fee will be very nominal. So just make sure you protect the word mark. Initially, when you get on a consultation with any of the participants, I mean, with any trademark attorney, they'll clearly say first protect the word because the .com or the handles, the social media handles, all are protected only by whatever the name or the wordings which you use. So I'm putting in the chat Google Maps, I mean the Google review link. Any other questions? Anybody who would like to unmute and share their experience? Probably it could be too much with respect to filing the trademark application, like the Infosys example or the overseas one. It could be overwhelming. Or for people, it's not new, then it'll be simple. But mainly for the participants, for the first time participants, it'll look like this is too much. Okay, so in the chat is a Google review link. Just hit a 5-star. Feel free to share your thoughts. So we have Ashu. Yeah, Ashu, please unmute and share, or you can also speak. And also there was one of the participants, probably from the startup. You can unmute and speak about the Tactic AI extension. Vinay Kumar Gupta Kopuri, and there's also somebody probably from their team. You can unmute and speak.
For our trademark,
yes, sir.
There is someone who opposed, which is having no link to our name, nothing similar, but they are opposing. So in that case, it is also pending since a very long time. So actually, what is the procedure that is happening at the trademark office to deal with such oppositions, which are not at all relevant in any sense, just to delay the registration or grant? They're doing such mischiefs. Is there any way for it?
Yeah, please feel free to share your brand name, sir. I mean, type in the chat. Our team in the office is going to check or probably share the screen, and they'll give you what could be the reason for the opposition. So feel free to drop it in the chat. What is the brand name or what was the trademark application name? Like, if you don't mind, they'll do the search and probably they'll share the screen and they'll give you what could be the.
I'll answer this one.
Yes, please go ahead.
Whether it is related or not, the first thing we have to do is after we get an opposition, within 2 months time period, we need to file a counter statement. That is mandatory. In our counter statement, we are explaining that these two marks are very different. So to give this explanation and all, we need to file a counter statement. But it has a time period. Within first one, after you receive opposition notice TMO, you need to file counter statement within the 2 months. In counter statement, you are explaining your clauses. So if you are not filing a counter statement, application will be abandoned. So we always request our clients to file an counter statement once they receive the opposition notice. Because only in counter statement, you're going to explain all your clauses.
Yes, that's true. But don't you think that this is a wrong practice to encourage opposition filings?
Yes,
So
yes, of course it is wrong, sir, but we need to at least counter it.
That's okay. But anybody is filing opposition, and the party who is in right position, they have to spend our counter statement every time.
Yes, sir,
So
I can understand, but that is
these
how
are
the law works.
This is
Trademark.
the all lacunae of the law. These are not refined. They are just
Yes.
giving unnecessary punishment to the real trademarks.
Yes, sir.
Could you share your name, sir, if you don't mind? Because the Zoom login could be your child's
Right.
name.
No, this is my name only. My short name is my name is Ashutosh Nanda.
Ashutosh. Okay, I'm sorry. So as Ashu, normally my daughter logs in and her Zoom name could be something short. So Ashutosh. Okay, thank you, sir. Would you like to share the brand name? Probably our team also can do the search. It'll be free. I mean, they'll do the search or probably they'll just check what could be the official reason also. Apart from the explanation which you just got.
The brand name is Elia, and the opposition of opponent's name is Enega.
Elia as in spelled as ELIA or
ELIEA.
could you repeat that, sir, if you don't mind?
ELIEA.
EA. Okay, somebody from the trademarks team at the office, probably you can just check.
Can I know which class it is applied for?
Categories.
Plus 3.
For which goods, sir?
Did you say?
Into cosmetics.
Cosmetics. Okay, sir.
Okay, did you say class 3, sir?
Yes.
Yeah.
Okay, class 3 cosmetics. Okay. Cool. So they're checking. Feel free to share the screen if possible, Spandana or Suma, so that this will be like a live demonstration quickly on. It's very frustrating, Ashutosh ji. I understand that probably somebody.
No, all stakeholders must give a complaint to the trademark office or registry to work on this. This is the unnecessary burden on the trademark office as well.
That is true, and
And there
also,
must be,
yeah, the support
there
system.
must be sufficient punishment for all these mischiefs.
Yeah, so mainly the IPR office, they have lots of pending applications, not only on this, but the support system is quite slow in terms of whatever the work is done. But you're absolutely right, sir. Probably they have to speed up everything, the support system, or probably the email support, or definitely there's no phone support like other customer service options. Mostly everything happens through electronic media. And so if you have that on screen, Suma or Spandana, feel free to share the screen. Let's
Actually, I'm trying to open the application and we will see the opposition notice and we can, after reading the whole opposition notice only, I'll be able to give you my comments, sir.
okay.
And,
Is this confidential, Spandana? I mean, with respect to whatever we are, is it okay if we share the screen and talk about it in public, or?
it takes
Everything
time.
in public.
Okay.
Everything is in public. No issues of
Okay,
that.
everything is in public domain. Okay.
It's a public, but I need to understand why they're opposing and all.
Okay.
No, as per my experience and understanding, I have noticed there are many small law firms, they are filing opposition just to earn some money from the company. They're working on numbers. They have nothing to work on relevancy or non-relevancy. They're filing opposition case showing to their big clients and dragging money from them and keeping unnecessary burden on the trademark office as well as the trademark applicant. So this wrong practice has to be stopped. And I think you all being the stakeholders, you must give this message to the trademark registry and office to
Yes.
take proper action on this. Otherwise, there will be a lot of pendency, will go on and pile up like anything. They are not streamlining the work. They are not taking the things in a practical way. So that's why everything is getting piled up. When one opposition is filed, that mark to get granted or registered, it takes years.
Yes, sir. Now, let me just.
Actually, status page is very slow, sir.
Okay.
So we will give a report on this later. Can we give a report on this later?
You can, Ashutosh ji, if you don't mind, you can drop in your contact information in the chat, or you can send a DM. Again, we will stay in touch. If you are already in our WhatsApp group also, our team members will follow up. So what I see, let me put in the chat. So Helia Wellness Private Limited. Okay. Okay, I see that. So I've sent you through a DM, Ashutosh, through it's the same information which is available. Let me send you a message. Okay. Okay, chat. So you can send us through a DM, sir. On Zoom chat, in direct message, Ashutosh ji, in private message I sent you. So you can drop in your contact information. I'll send it to the team, the trademark team, and they'll follow up with you in case if there is any help needed. They'll certainly share the feedback which you provided with the trademark office because again, okay, we got your contact number. Thank you so much for all the participants. If you have any further questions, feel free to send us a DM or probably drop us an email at contact@evatech.com. Thank you so much, Asir Rajaselvan, sir, for tuning in live and for being which city you're from, sir? Are you from Chennai?
Chennai.
Chennai. So the distance between Chennai and Hyderabad is less now. Thank you so much for tuning in live and feel free to drop in our officer in case if you come to Hyderabad.
Definitely.
So for all the participants who have joined, we have Maheshwar joined in at the end of the but do catch the replay. I'll catch the replay. I mean, I'll share the replay link. Okay, from our official YouTube handle, everything, almost all the handles. Yeah, Maheshwara Mudila ji, do you have any questions, sir? I see you just joined in with respect to trademark application. You're on mute, Maheshwara, sir. Yeah, good to see you, Maheshwara Garu. You're on mute, sir. We can't hear you. Yeah, we have. Do you have any question, Maheshwara Garu? No, you're on mute. We can't hear you. Okay, let me unmute. Yes, sir.
So just I joined, sir. That's why I'm not hearing that previous discussion, sir, actually.
That's okay. I mean, we are done with the complete presentation and this particular webinar. Do you have any questions with respect to trademark filing or trademark applications?
Present, I don't have, sir.
Okay, no problem. So
Okay.
please join us live again 11:30 next Wednesday with
Sure, sir. Sure, sir. Sure.
Thank you so much.